Welcome to the third webinar in the spring season of Contemporary Challenges to American and Global Law. I am Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and LLM program, in which Catholic University has cooperated with Jagiellonian University in Krakow, Poland for many years, and I will be your moderator. Christina D'Amelio Lopez, Director of Advancement in the Law School's Development and Alumni Relations Office, will bring greetings from the Columbus School of Law of the Catholic University of America.
Thank you, Professor Wortham. Can you hear me? Everybody
Yes,
can.
Perfectly.
Hi, all. Thanks so much, Professor Wortham. Thanks for curating another really outstanding program for the law community today. As we noted earlier when we got on this call, this is the 14th program in the web series with two more, one in May and one in June. So I hope you all will join us for that. Professor Wortham's leadership in this has been really outstanding. And she's had so much vision. The execution, even with the little glitches today, has been almost close to flawless. And that's really saying a lot for the virtual programs and relying on technology for us to get together. We're really pleased to have grown such an important relationship with the Jagiellonian University, and very pleased to welcome Aleksandra Kustra-Rogatka from another law school as our commenter in Poland, another law school in Poland as our commenter to our Columbus Law professor, Mary Leary. I also want to thank today Luke, Gaspar, and Wojciech for their outstanding coordination of this web series. They've done a great job marketing it, and as we can see today, we had 140 people registered, so that's really fantastic, and we thank them for that. We remember to acknowledge these programs and the 30-year relationship that's been established between Catholic law and the Jagiellonian University, and not to forget its founder, Emeritus Professor Rhett Ludwikowski. We also welcome International Business and Trade Summer Law Program folks, the American Law Program, and the LLM in American Law, which now has more than 200 US, Polish, and international alumni. Our program today on the commonalities of Black Lives Matter and the MeToo movement, both social movements that we are all personally aware of, have been shared experiences across our global community. Timely topics such as ours today are critical in building and maintaining a really strong dialogue between Catholic law and the Jagiellonian programs that have been fostered. Thank you all for being here with us. We really value your participation and look forward to seeing you again for the next two programs.
Thanks so much. One little amendment, actually, our cooperative programs have almost 2,000 alumni of our US and international alumni. So it's an amazing accomplishment over almost 30 years. So I now turn to Wojciech to give us greetings from Jagiellonian University.
Thank you very much. Dear participants of the series of webinars, it's a great pleasure for me to express on behalf of the Jagiellonian University the great joy that all of you joined us in the online meeting, showing your interest in the contemporary challenges in American and global law. We are very happy to observe such a huge audience who shares our passions. Our meeting here allows to hope for common undertakings in the future. Thus, we look forward that the developing cooperation of the Jagiellonian University with the Catholic University of America continues. Also, this position lets me present the gratitude to all the persons without whom it will never be possible for this event to happen. Again, the activeness of so many people proved that the transatlantic cooperation strives even during the pandemic times, despite technical problems and without the possibility to meet in person. To conclude, we are really excited with a new way to learn and to meet together. At the same time, we do hope that sooner or later, and hopefully sooner, we will all meet in person during our programs or alumni events.
Thank you. And Christina already graciously mentioned a number of the people who've made this possible. We've really had a team that has been terrific, starting with the deans of both of our law schools. We do have 2 remaining programs. May 12th, I know many of you are alumni who fondly remember Professor and for a time Dean Jefferson, and we hope you'll join us on May 12th, where we also have another distinguished Polish academic as a commenter. And then on June 2nd, we have our, June 5th, excuse me, our final webinar, in which we will return to business and finance topics with Victor Furman, who is one of our LLM graduates and a lawyer in Stockholm, Sweden, with a comment from JD alum and Deckert firm partner, James Catano. So I expect most of you have used Zoom before. Please type your questions in the chat. If you would rather type them individually to me, to Mr. Banchik, or to Gaspar Code, we will convey them for you, but you may just type them yourself in the chat. Professor Leary will speak for about 20 minutes, and that will be followed by the comment from Professor Kustra-Rogatka, and then she will lead off with a question or 2. The session is being recorded for about 60 minutes. We got started a little bit late, so we'll probably continue the recording till about 2:10, and then we'll have the half-hour of Q&A. So we'll probably go to just a little bit 10 minutes later than we normally do because of our delay in starting. So Gaspar, you can go ahead and put in the chat some links to bios for our distinguished speakers. And I will also read a shorter version of those bios. Excuse me, I have to switch to a different document myself. Okay, just 1 second. All right. This is one of our days as we get to the end. Okay, here we go. So, Professor Leary is a national and international expert in criminal law and procedure, victimization, exploitation, human trafficking, missing persons, technology, and Fourth Amendment search and seizure law, and teaches related courses. She is the lead author of Perspectives on Missing Person Cases from Carolina Academic Press. She's testified before the Senate and House, and currently is chair of the Victim Advisory Group for the United States Sentencing Commission. Prior to joining the CUA faculty, Professor Leary was a federal and state prosecutor and worked primarily on abuse and exploitation of children and women, child pornography, sex trafficking, and family violence cases. Professor Aleksandra Kustra-Rogatka holds doctoral and postdoctoral degrees in law. She is a university professor of law at Nicolaus Copernicus University in Toruń, Poland, where she is taught in the chair of constitutional law and headed the Department of Theory and Law and State. Her scholarly topics include non-governmental organizations, dealing with democracy and rule of law, European integration on constitutional law, Polish judicial review, transitional justice, and rule of law in Europe. From 2008 to 2017, she was a law clerk in the Polish Constitutional Court. She's been a visiting researcher at prestigious universities in Göttingen, Germany, Berlin, and Rome, as well as engaging in cooperative projects with universities in a number of countries. Recently, she has been an academic fellow for the project Reconstitution, a program of the Forum for Transregional Studies and Democracy Reporting International, coordinated by the Humboldt University in Berlin. She is a member of the editorial board of the Comparative Law Review, as well as an article reviewer for other distinguished journals, and a member of preeminent scholarly associations in philosophy of law and constitutional law. She participated in the CUA-JU International Business and Trade Summer Law Program in 2004, so we proudly claim her as our alum. So we will now turn to Mary.
Thank you very much, Professor Wortham. Let me thank you all for inviting me to participate in this. Special thanks to the team that put this together and Professor Wortham. When I joined the faculty at Catholic University, one of my colleagues said our program with the Jagiellonian University is the crown jewel of the law school, and that is certainly true. We're very lucky to have this partnership, and we're particularly lucky to have Professor Wortham as leading this. I also want to thank Dr. Kustra-Rogatka for her time. We've had some wonderful conversations in preparation for today, and she's going to offer such a wonderful international perspective to some of my comments. What I propose to do for the next 20 minutes or so is to spend a little bit of time to discuss how this research project came about that I'm looking at. And in so doing, have a little bit of history and definitions about Black Lives Movement and the hashtag #MeToo movement, just for purposes of our discussion. And then I'd like to talk about the emergence of some areas of tension between these two movements that have arisen both in mainstream discussion as well as academia, and offer a framework, a suggestion, a path forward where I believe that both of these movements can facilitate the synergy that they have with each other and hopefully advance both their causes. So, how did I get involved in this space? You heard my bio. I am not a civil rights scholar, nor do I claim to be one. This particular project emerged from a prior paper that I wrote for Louisiana Law Review, looking at the Me Too movement and its potential impact on criminal sexual assault trials. I was specifically trying to focus in that piece on improving outcomes for criminal sexual violence cases here in the United States. Now, history tells us that movements, social movements, they come and they go. And some ebb to a trivia question 20 years later, but others can stay and have lasting impact. And when we're in the midst of them, it's been my observation, they're all equally intense. And it's hard to determine which movements will last and thrive and ultimately impact public policy. So I was interested in looking at Me Too and seeing if it could ultimately impact one of my areas of research, which is sexual violence against women. And I was particularly interested in this because we have a tremendous problem in the United States regarding the attrition of sexual assault cases. And what we know is that at each stage in which the government has a friction point with the victim survivor, the cases fall off. We know that victim survivors report not only less than 50% of cases, but by some counts as low as about 20% of cases. Then when they interact with law enforcement, more cases fall off in terms of what actually gets investigated. When we get to prosecutorial discretion, there's another space of attrition where prosecutors fail to decide to pursue particular cases. And then we get to trial and there's further attrition. And all of these points, we have a fallout. The research tells us that much of this has to do with related perceptions and false perceptions of victims of sexual violence, adherence to rape myths, rape culture, as well as stereotypical views of quote unquote what a true rape victim is, how he or she should behave, what he or she looks like, etc. And due to these views, we see that negatively implicating the decision makers all along the way. And I thought the Me Too movement has some real potential here because it openly rejected the underpinnings of this misplaced, entrenched views of the public, potentially changing the perceptions of these decision makers and ultimately jurors. And I would suggest to you that it does that by explaining the vastness of sexual assault and harassment and elevating the millions of men and women who didn't report these crimes, but then engaged in the self-disclosure. It blows up, frankly, the perception of the quote unquote real rape victim as someone who immediately reports and is not traumatized by the event. And it did this in both a qualitative and quantitative way. Just for a minute, I'd like to give a brief sort of history or context to the movement. Many of us assume or think that the movement started in 2017 when famous actress Alyssa Milano invited survivors of sexual harassment to respond to her tweet with a simple hashtag #MeToo. And this was all in the wake of the Harvey Weinstein revelations. And the result, as we all know, was a massive global outpouring of self-disclosure. And within only a few months, there were 12 million retweets of this invitation. However, the movement actually began in 2006. A woman named Tarana Burke had founded Just Be Incorporated to work with young survivors of sexual abuse, who primarily were girls of color. And Ms. Burke talked about the phrase "Me Too" that she began emerged from her own experience as suffering from prior sexual trauma and wanting to say "Me Too" to these children, wanting to engage in that quantitative and qualitative important connection that I've experienced that trauma and that you are not alone. There's lots of definitions out there. I'm going to use one from Margaret Johnson, who defines Me Too as a narrative movement by people, primarily women, telling their stories of sexual harassment or assault. It brings to the surface the stories that have been silenced, untold, or overlooked. And these narrative collections can and do effectuate gender justice change by empowering people, changing perspectives, opening up new learning, and affecting future legal and non-legal outcomes. Not a perfect definition, but that's at least what I am talking about. So at the end of that first article, I expected my next article to turn to how this movement might affect legislation. I had looked at the courts, I expected it to legislation. But then the late spring and summer of 2020 came to the United States. And with that, we and all of us in the world watched the horrible, tragic murder of George Floyd, live on or recorded on video, all over 9 minutes of it. And that, as we all know, reinvigorated the Black Lives Matter movement. Now that movement on its part also had started much earlier in 2013. A movement also founded by African-American women, self-defined feminists, Alicia Garza, Patrisse Cullors, and Opal Tome. And they started the movement in the wake of the murder of Trayvon Martin, who had been killed by a self-proclaimed neighborhood watch person who was later acquitted in 2013. That work was amplified and continued through 2014 with the public killings of many people, and only a few of them: Eric Garner, Tamir Rice, Michael Brown, none of whom had the police who were caused their death prosecuted. And like the Me Too movement, it experienced a second resurgence, in this case in 2020, with the death of George Floyd. And that ignited global protests throughout the world, 60 countries, every continent. And these protests, even according to news reports, in front of the US consulate in Krakow, Poland. So what's the definition of the Black Lives Matter movement for our discussion? That's a little bit harder to define because by definition, this movement is intentionally decentralized. But they do have what is referred to as a Black Lives Matter global network, in which they define themselves as a chapter-based, member-led organization whose mission was to build local power and intervene when violence inflicted on the African-American community is inflicted on the African-American community by the state. The chapters throughout the country seek a broad range of societal changes beyond an end to police violence. And what we've found, and why it's a little bit more decentralized, is each of these chapters has different sets of what they label as demands, and they do run the gamut. So as that movement was reemerging in 2020, I got to thinking, well, what's the effect of these two movements? On the one hand, they have very clear historical parallels. They are both grassroots movements. A tragic event, personal event, transformed and amplified in the public sphere. They're both founded by self-described African-American feminists, and they're both deal with situations where oppressed people, the mainstream, are faced directly, unable to look away at the raw trauma that this violence has caused. And I thought that they shared these similarities And they might be able to capture that attention that both of these marginalized groups had been seeking. Because the reality is, prior to this, the numbers are shocking. As we all know from the news in the United States, African Americans are only 13% of our population, and yet they are disproportionately affected by police violence. We know that women, there's some frightening statistics that according to the CDC, 19% of American women report having experienced rape through their adulthood, and 43.9% sexual violence. With either of these sets of numbers, I used to say this when we weren't in an actual pandemic, but it's true. We would have called this a pandemic. We would have reacted and said, gosh, we have an illness. It's affecting half of our population, or so grossly disproportionately affecting a segment of our population. And yet, the needle hasn't moved a whole lot in either of these areas. And so I think they share that history. But then I was struck by the differences. And I think when we look at these two movements, there's sort of three layers to look at. First, the most simplistic layer is, well, gosh, they're very similar, right? They're marginalized group and they're calling for accountability, particularly accountability of law enforcement. But if we look a little deeper, I think we see some of the tensions. The role of the police highlights this. For the Black Lives Matter movement, of course, the police and by extension, the government are the perpetrators of the violence and oppression. Whereas in the Me Too movement, the role of the police and the government is more a failure to act, a failure to intervene, a failure to respond. And so that brings me to the third level, where I think we see some of these tensions between the movements. The Me Too movement, whose language, I mean, think about it, Me Too is really acknowledging a shared experience, trying to recognize the universality of that, is fundamentally about more government intervention, about a more robust response to these scenarios of policing, prosecution, and regulation, is about addressing the gaps that we see. Cities that have rape kits that have never been tested, the allowance of non-disclosure agreements in sexual harassment cases, those sorts of things. And they seek to interrupt this sexual violence by altering cultural norms and providing more access to justice systems through legal modifications and increased government intervention. Time's Up, the legal arm of this movement, has 4 prongs: increased legislation, increased litigation, industry-specific efforts, and public awareness. By contrast, the Black Lives Matter movement, on one level, and that language, Black Lives Matter, some scholars has described it as not a shared experience, but rather an alert, an announcement or a highlighting that this is a unique experience that needs to be recognized by the mainstream. And there, interestingly, they don't speak of goals, but many of the chapters talk about demands are for less policing, less use of incarceration, less use of the carceral state, decreased role in government, etc., which has perpetuated some of the oppression against this particular group. And while it's more difficult to ascertain their particular goals because it's chapter by chapter, just a few of them include the DC and Los Angeles chapters want to completely defund police department, not just the catchy phrase, they want to completely defund it. Chicago and many other cities have talked about removing the police from schools entirely. And one must ask, well, what does that do? It may be good, it may be bad for victims of sexual violence in high school, which we know to be a major problem. Chicago also calls for automatic diversion of all offenders under 16. That, again, what does that speak to victims of sexual violence? And Philadelphia calls for an end of the carceral system entirely and a closing of the police academy. So I began to wonder, what's the effect here? What will the effect be on either the Black Lives Matter movement, on the seemingly older movement of Me Too, or vice versa? And I expected the scholarship to be looking at this as well, sort of looking at that, these tensions. But interestingly, what has seemed to emerge, in fact, is the scholarship explicitly criticizing the Me Too movement And much of the scholarship that is currently emerging, and of course it's more is emerging every day, is really looking at Me Too specifically and the feminist legal reforms movement that changed our rape laws more generally, and characterizing them as, quote, one scholar put it, strengthening the carceral state disproportionately harming communities of color. So really saying not only are these in tension, but some feminist legal scholarship in this space has actually led to some of the causes of the oppression that folks in the Black Lives Matter movement are concerned about. Similarly, one scholar went so far as to say, in the zeal to fight sexual misconduct, feminists have abandoned their liberal commitments. And so the research suggests, at least the early legal scholarship, this tension exists, and that Me Too is the goals of Me Too are perhaps largely an obstacle to the goals of Black Lives Matter movement. And I have to say, I found that troubling. Troubling because both of these movements have such potential, right? Both of these movements are so important, especially to marginalized groups. And I began my comments with talking about what makes a movement last and have impact. And when we look historically, sometimes what can diminish a movement's impact is this sort of thing, the infighting, right? The challenges, the belief that justice is a finite resource and that there's only pieces of it. So I really wanted to think, how could we frame these, recognizing they don't have to line up entirely, but how can we frame these such that they can be seen as complementary? And what I'd suggest is that if we look at these movements through the lens of the crime victim, we can see a path forward where they both can advance. When viewed through that lens of criminal victimization of marginalized groups, the similarities emerge. These movements both regard marginalized sections of society that have been individually victimized through traumatic violence. But the causes of that victimization are not individual, but systemic. That is to say, both of these groups are verbalizing a normalization of oppression and a victimization that is grounded in dehumanizing these groups to some extent. And I would suggest that if we frame it in that way, these movements can be seen as a response to, frankly, the tolerance of this victimization of these particular marginalized communities. Because fundamentally, these groups are groups of survivors who've experienced trauma because their victimization was simply seen as a cost of doing business. That's how it is in the workplace. That's how it is if you engage in this behavior or that behavior. That's how it is when you get into contact with law enforcement. And that is simply such an important contribution these groups make to improving our society. So what I would suggest, now that may not sound revolutionary, right? Okay, of course they're both crime victims, but what I'm suggesting is what is unique about these groups are 4 hallmarks that they share. First, accountability, but not just the fact that both movements call for accountability. Everybody calls for accountability, but both of these very importantly talk about accountability and prevention. Accountability for the conditions that make these marginalized people vulnerable, whether it's racism, sexism, or acceptance of a certain level of violence against these groups. That is to say, both these groups call for recognition of the microaggressions that these groups have experienced, which enable the violent victimization. Also with accountability, when prevention fails, accountability to those who violate their legal duties by either commission of violence against these groups or omission of their duties. That is to say, accountability for the macro aggressions and the violence that they endure. So with this concept of accountability, I think there are these 3 other hallmarks which feed into that they both champion. First, human dignity. A basic element of a crime or a legal constraint is the recognition of a social harm. And to recognize something as a social harm, one must value the person or the group as deserving of protection. And so these movements both underscore that me too, I am worthy of this protection. I have the shared experience. Black Lives Matter. We are worthy of this protection. This is our experience. The third hallmark, they both focus on not only the individualized victimization, but the systemic problems. Both groups are seeking more than addressing the outcomes of individual acts of violence, but to address the systems that enable them to occur. And finally, perhaps most importantly, is both groups call for a change in our social norms. As I've alluded to already in my comments, overlaying all of these are the recognition that we need to shift social norms. Again, Me Too is talking about sharing a personally held secret. Victim survivors are not the other, but they are your sister, your brother, your coworker, your family members, your friends. And that image that mainstream society might have of the quote unquote true victim is simply false. Black Lives Matter similarly says that the stereotypes and bias toward people of color, the stereotypes and biases to the public perception of what is all right for the law enforcement to do, et cetera. We need to change those expectations with regard to that and have effective law enforcement and investigation, et cetera. The good news is we've done this before, and we've done this before with domestic violence, a crime in which for many years it was accepted. It was the norm. And now, of course, it is not the norm. At least we're not as far as we want to go, but we certainly, it is stigmatized, it is illegal, it is not accepted as the way things are. We see that with child abuse, we see that with hate crimes. And what I would suggest is by reframing these movements through this lens of the crime victim movement, with both individual and systemic characteristics, the complementary nature of these movements emerge more clearly, and they both can advance to help achieve justice for all of us together. So those are my comments.
Thank you so much, Mary. We now turn to Professor Kustra-Rogatka. I think you're muted.
Okay, now I hope that you can hear me. Yeah, I thought that I will do it without headphones, but it turned out that it's impossible. So first of all, let me thank you for inviting me here and for having me here. It's a pleasure, but it's an honor to comment to such a fascinating topic. So thank you very much for this opportunity. And I will try to keep my comments short because I have prepared a few questions, not one or two, but four. And I would really like to ask all of them. I think that it will be a good start for a longer and richer discussion. So I will start with a very general comment or statement that both Black Lives Matter and Me Too movements are definitely very complex social justice movements, and they implicate a range of identity characteristics. Although some of legal scholars prefer to assess gender and racial harms as occurring on separate axes, I think that they are comparable and they should be compared. And in this context, the question posed by Professor Leary in the title of today's extremely interesting speech is very crucial. Especially because some claim that identity politics is divisive, and at the most fundamental level, it is, as it requires recognizing that we are different, individuals are different, and they are different from each other. But what the identity politics does is the transformation of these differences into social and legal categories. And I think that we should be aware of it when we speak about those social movements. I absolutely agree with Professor Leary that both movements do not necessarily have to be seen as remaining in tension. Together, they lead to consistent accountability and thus to a more effective and more legitimate justice system. Both of these movements are a rejection of institutions and traditional hierarchies, and they are both essentially leaderless movements, as far as I can see it. In addition, as Professor Leary mentioned, they were both founded by Black feminists who embraced an intersectional analytical framework. I think it is quite important to point out that these two movements can learn from each other's experiences. And one issue where the hashtag #MeToo movement somehow benefits from the Black Lives Matter experience is the movement's name and its inclusiveness, whereas Black Lives Matter was immediately attacked for not being inclusive enough, with counterclaims of all lives matter, blue lives matter. MeToo movement, as a matter of branding, is a masterpiece. It is as inclusive as it can only get. There are, of course, different messages behind those names, the movement names. They reflect different orientations towards social action and justice. In my opinion, MeToo, hashtag #MeToo, at least on the level of linguistic analysis of its name, is focused on individual empathy, whereas Black Lives Matter on explicit ethical demands. Nevertheless, the centralized component of the MeToo movement, which is the Time's Up organization, also put emphasis on ethical demand in its name. I would not be worried about tensions between goals of Black Lives Matter and MeToo, especially with regard to law enforcement on one hand and the incarceration or even the criminalization on the other hand. I agree that accountability and prevention are key ideas in both movements, and after all, one of the main claims of the Black Lives Matter movement is the police accountability for the abuse of their powers with respect to women and men of color. However, one of the main threats to both movements is the tendency to focus on one oppression at a time and to decrease focus among both groups on the relationship between race and gender-based oppression. So this was, I think it was a very important statement which was made by Professor Leary when she said that one of the hallmarks of both movements is human dignity. I think that they should avoid undermining each other and focus on human dignity as the most universal value. This reminds me about the similar challenges facing social movements in Poland today. I mean, feminist movements and LGBT movements, they both fight against the oppressive politics of the right-wing government. However, they did not escape a few glitches, at least on the leadership level. And here comes my first question to Professor Leary, which is about learning from prior movements or other movements in other countries. But with regard to Black Lives Matter and hashtag MeToo movement, I would like to ask about the relationship to the earlier legal and social movements. To what extent do you view Black Lives Matter and the hashtag MeToo movements as outgrowths or maybe even evolutions from prior social and legal movements in the US?
Thank you so much, Professor. It's a really great question. And again, being a good lawyer, I have, caveats, right? And one is I'm not a civil rights scholar, of course, or civil rights history. But in thinking about that issue, I think on the one hand, they are outgrowths of an ongoing feminist movement, of an ongoing civil rights movement for people of color. And specifically, they both interestingly have followed that American tradition of developing the legal arm. As you point out, Time's Up is specifically about legal responses, litigation and legislative responses. And similarly, Black Lives Matter has created a similar legal arm to advance their goals, laws for Black life. And that, of course, is a long tradition of the Women's Law Center here in the United States, NAACP Legal Defense Fund, et cetera. I think, though, what is maybe different, or what has these to have the potential for longstanding change, is that they've captured the middle. And that's not to say you have to capture the middle in order to succeed. But my observation has been, as someone who's looked at this with regard to criminal victimization on children, the thing that gets people outraged is when they can't look away. We don't want to see victimization of people. We don't want to see it for a host of reasons. Both of these had an event or two or three that people couldn't look away. And maybe part of that's technology in the world in which we live. That absolutely could be it. But you can't deny these things are happening. You can't deny 12 million claims. You can't deny the videos. And I think that it adds a new dimension to it. And just anecdotally, so a Professor Graw Leary observation, which is I say to my students that in a quarter is worth a quarter, but you heard so many folks just on the news and interviews at these marches commenting on the diversity of the marches this summer post George Floyd's murder. And many civil rights activists saying, I haven't seen that, and that feels different. And again, that's not to suggest that's necessary, but I think that may add a dimension that is a welcome improvement in our history. I see on our audience, Professor Duggan, who's very active in this work. She may have something else to say when we get to the chats about her experience in publicly working in this space.
Thank you. I just wanted to say again to our audience, we're sorry. This is the first time we have these kind of technical glitches, so we got started a little late, but we are going to go to 2:10's 8:10 in our recorded part, and then we'll go to our 30 minutes. So we will be running, we will go a little 10 minutes over because we got started late. Again, if anyone has to leave, of course, we're sorry, but we're glad we got it solved. So Professor Kustra-Rogatka has some more questions, so I'm going to turn back to her. And again, we will be staying on till 10 after the hour with our recorded part and then switching.
Yes, thank you very much. Professor Leary mentioned Time's Up as the component which is focused on legal solutions. And here comes my second question, because we are talking today about social movements, and we try to think about them as legal scholars, as academics, probably also as lawyers, and I mean practicing lawyers. And I wonder if you think that law has potential to produce transformative solutions to such social phenomena that led to either or even both of these movements, to Black Lives Matter and to MeToo. And do you think it is more, or maybe it is more obstacle, maybe the law poses an obstacle to such a transformative change, because you can see it both as a chance, yes, legislative changes which will transform the legal system, or you can also see the law as an obstacle itself. I don't know which view would you prefer. Pessimistic or optimistic for lawyers?
Well, we're all lawyers, aren't we? All pessimistic, I think. But I think it's a really great question, and it's something that I've wrestled with a lot in my more the scholarship that I spend most of my time on, and that is to say, does the law lead a social movement, lead social norm change, or vice versa? And in my thinking about it, I think that it depends, right? We've seen the law lead here in the United States in some ways, or the law follow. You know, environmentalism here in the United States, I would say the people lead and the law is slowly following, right? You know, the last to get on board seem to be our legislators, at least nationally. But in other contexts, the law gets ahead of things. For example, in our human trafficking law, in the United States, the Trafficking Victims Protection Act, which is our codicil to the Palermo Protocol, I don't think Americans were talking about human trafficking until the legislation was passed and we introduced that term into our dialogue. So in my thinking about this, though, and in a previous article I wrote, I really think that the key is, with regard to that relationship, for any social movement to be successful, there are three components. One is education of harm. And by that, I mean really explaining to the public what's the harm. Two, legal reform. The laws often follow that reflect that harm. Henry Hart tells us that a criminal conviction is the moral condemnation of society. Well, you therefore have to have the community in sort of some agreement as to what should be condemned. And then third, social stigma. People have to recognize something as bad. And the best example I have for this, although it is not a terribly deeply philosophical one, is our drunk driving movement here in the United States. That movement was not even talked about until Mothers Against Drunk Driving arrived on the scene. And the mothers of victims of drunk driving accidents, brought that harm, what that harm was like to have lost a child to that kind of accident. What followed? Legislation here in the United States, blood alcohol laws, mandatory minimums for accidents, things of that nature. Completely never heard of before, completely fought against by most institutions. And then social stigma. So today, teenagers, that's not something that's okay. You know, the days of Mad Men television where people had cocktails in their offices and then drove home, that's just not acceptable, I would say, today. And I think that is an example of you need both in order to really make an advance.
Yes, I definitely agree with this. I think that law is not enough, definitely. It can be only seen as an element of broader social change, but it can't do everything, as it can't change the society. The society has to change itself. At least to some extent. Well, I think that this statement is at least a little bit connected to the third question that I would like to ask, which is about the success and failure. I mean, we know that social movements come and go. And sometimes we don't remember them very well after a few years. Sometimes they change societies, I would say, forever. Now we are in the middle of those changes with regard to Black Lives Matter and the MeToo movement. And I would like to ask you about how to measure success or failure of those movements, because I think that it is not I'm absolutely aware that it is not an easy question to answer, but still I would like to ask it. I think it is a fascinating one. So yeah,
I think it is a fascinating question and not easy to answer. And I don't have a clear answer, right? What I would say is certainly legislative reform is not the measure. And the great example of that would be here in the United States. There was a moment of great legal reform when it came to rape law in the United States, led by our feminist legal scholars. Things like not requiring corroboration, things like the exclusion of the marital rape exception to rape laws, things of that nature. But as one of our leading legal scholars in this area, Deborah Turkheimer at Northwestern, has noted, it really didn't translate into decreases in sexual assault crime or more successful prosecutions. And I think that's because the law was there, but the social norms weren't. So what it's not is just legal reform. And you're quite right. Time's Up claims great success. And they've had a whole campaign, 20 states by 2020. And I believe they met their goal in terms of some state level legislative changes. It's not enough. We'll see. That being said, it is something, right? And as we all know, the current bill in the House, the George Floyd Justice and Policing Act, passed the House here in the United States, but it is considered not hopeful in its current form in the Senate. And the failure of legislative reforms to succeed, I think, can be really harmful. So it is a pessimistic answer, and that legislative reform is not enough, but the failure to succeed in them, I think, can really be, I don't want to say defeatist, that might be too strong a word, but demoralizing to movements. So.
Thank you.
Thank you very much. And my last question is maybe about a little bit different aspect. I would like to ask you about the future of those movements, but in the context of intersectionality. Do you think that intersectionality will affect the future of Black Lives Matter and #MeToo?
That is a great question. And I have to say, when I started in the research in this space, I expected a lot more discussion of intersectionality. And I would say only recently, in the last 6 months or so, have I seen more of that discussion. And when I speak of intersectionality, I'm thinking of Professor Crenshaw's coining of that term, where she talked about the multiple characteristics that a person experiences, right, that can lead to their oppression or discrimination. And I think that there's a lot of promise in intersectionality in this space, because ultimately that is a victim perspective, and it calls for not cookie cutter responses, right? It calls for recognizing the human dignity of the individual survivor. So rejecting sort of oversimplified, what's the word I'm looking for? Stay in your lane responses. But it also possesses those 4 hallmarks I talked about, right? Accountability, human dignity, systemic, recognizing systems, and the need to change norms. And I think Dr. Crenshaw's or Professor Crenshaw's view is the norm is you think there can be only one form of victimization. The law reflects that when there can be multiple forms of victimization. So I do think there's a lot of promise there. Having said that, I'd be remiss if I didn't note one scholar who noted the overlap, Professor Keisha Lindsay, and she noted that there's overlap in these movements, but as they've grown, her observation is they've tended to both focus on one form of oppression or the other, and have missed the opportunity to retain that intersectionality as a framing function. And I thought that was an insightful observation. So stay tuned, I think, but I'm believing that that's got to be a part of this path forward. And I hope that Professor Lindsay's is an observation and not a prediction, but we'll see.
Thank you for those wonderful questions and great answers. I think this is the point. First, I would mention that on Thursday this week, April 29th at 6 p.m. Polish time, we have an LLM information session. If there is anyone interested in joining us, I think Gaspar will put the link in the chat. You can link there from our Facebook page. And we have a very interesting question from Arthur Yagiello in the chat. I think that we'll make that the lead off of our next section. And because he raises a constitutional law question, I would guess one of the first things Professor Leary and Kustra-Rogatka will say is, I'm not a constitutional law professor. All they can, well, actually, Professor Kustra-Rogatka is, so we will. But we also have Professor Duggan on, who is a constitutional law professor. So we might also ask her if she wants to chime in after they respond. So I'm going to end the recording button now, but we'll just continue right on. And as I said, if you want to join us at the LLM info session on the 29th, that's great. And so I'm going to